Muy buenas tardes. Saludo a la delegación del Ilustre Estado de los Estados Unidos y a la distinguida representación de las presuntas víctimas. Doy por declarada abierta la audiencia en el caso 14-042, Anastasio Hernández Rojas y familia, respecto de los Estados Unidos. Paso la palabra a la secretaria ejecutiva Tania Renaud para que realice una referencia en relación con el caso materia de esta audiencia.
Gracias, presidenta. Muy buenas tardes y buenas tardes. Un saludo al ilustre Estado de los Estados Unidos, a la representación de las víctimas, un saludo a la sociedad civil. El presente caso se relaciona con la presunta responsabilidad del Estado por la muerte de Anastasio Hernández Rojas por parte de agentes de la Oficina de Aduanas y Protección Fronteriza de los Estados Unidos de América, que ocurrió el 31 de mayo de 2010. Mientras estaba detenido en un centro de detención y patrulla fronteriza, así como por la alegada situación de impunidad del caso. El 23 de julio de 2020, la Comisión aprobó el informe de admisibilidad número 185-18, que declaró admisible la petición en relación con los derechos establecidos en los artículos 1, 2, 18, 25 y 26 de la Declaración Americana de los Derechos y Deberes del Hombre. La presente audiencia tiene por objeto escuchar las declaraciones de una presunta víctima y de un testigo, profundizar los alegatos de fondo de las partes y recibir información sobre la situación actual del caso. Gracias, presidenta.
Muchas gracias. En primer lugar, la comisión escuchará la declaración de María Puga Morán en calidad de presunta víctima. La señora Puga describirá los presuntos.
Yo no tengo audio.
Tendrá hasta 10 minutos para realizar su interrogatorio. El Estado ha informado a la Comisión Interamericana que no realizará un interrogatorio. Posteriormente, la Comisión pasará a formular las preguntas. Declarante, sírvase indicar su nombre completo, lugar de nacimiento y lugar de residencia.
María Puga, mi lugar de nacimiento, Nayarit, México. Resido en San Diego, California, de Estados Unidos.
Muchas gracias. Le paso la palabra a la parte peticionaria para que realice su interrogatorio por 10 minutos. Adelante.
Gracias. María, ¿cuándo conociste a tu pareja, Anastasio?
Yo conocí a Anastasio cuando yo recién emigré a Estados Unidos en el año 89.
¿Cómo era Anastasio como pareja, padre, hijo, hermano y amigo?
Anastasio era un gran hombre, era un gran padre, un gran esposo, un gran hermano, un gran ser humano.
¿Y cómo te enteraste de lo que a él le había sucedido el 28 de mayo de 2010?
Yo me enteré hasta el 29 de mayo, cuando un oficial fue a la casa y me dijo que Anastasio había tenido una pelea y que estaba en un hospital.
¿Qué pasó en el hospital?
Después de cuando nos dieron esa noticia, nos fuimos al hospital. En el hospital no nos daban ningún tipo de información. Nos dijeron que Anastasio no estaba ahí, que ahí no había nadie. Después nos dimos cuenta que Anastasio tenía muerte cerebral. La familia, todos lloramos a llanto. Aún así, de todas maneras, no nos dejaron mirar a mi esposo. Pasaron horas cuando solo a mi hija y a mí me dejaron entrar a mirarlo. Cuando yo llego a ese cuarto de hospital, miro a ese hombre fuerte, grande, mi esposo, el amor de mi vida, tirado en una camilla llena de tubos, inconsciente y todavía rodeado de oficiales que lo estaban resguardando como si él se fuera a parar y correr de ese lugar.
¿En algún momento un oficial te explicó lo que le había pasado?
En ningún momento nadie nos explicó qué había pasado. Nadie sabíamos qué había pasado. Nadie.
¿Cómo te enteraste de más detalles de lo que sucedió?
Me enteré después, el día precisamente de su funeral, cuando llevamos a Anastasio a descansar. Yo iba al baño, el televisor estaba prendido, pues empezó a difundir ese video. Cuando yo voy a pasar al baño, escucho esos gritos de dolor que gritaba mi esposo. Me regresé al instante y ahí dije, es Anastasio, es Anastasio. Me llené de dolor, de rabia, de impotencia, del escuchar cómo mi esposo gritaba, cómo gritaba de dolor, cómo pedía ayuda, pero aún así, o sea, yo todavía en ese tiempo decía, pues, ¿qué pasó? ¿Por qué? ¿Por qué? ¿Quién le está haciendo esto? O sea, no sabíamos todavía quién le estaba haciendo esto a Anastasio.
Cuando salió el segundo video, 2 años después, ¿qué es lo que viste?
Cuando sale el segundo video, que miramos esas imágenes como mi esposo estaba rodeado por todos esos agentes golpeándolo, humillándolo, torturándolo. Ahí es cuando te das cuenta de por qué Anastasio gritaba, por qué mi esposo gritaba. A mi esposo le dolían todos esos golpes, no después de verlo golpeado, ponerle la pistola eléctrica, todavía le quitan su ropa, lo humillaron después de torturarlo y golpearlo de esa manera. Yo no puedo entender cómo esos oficiales no tuvieron piedad de ese ser humano que estaba tirado boca abajo en el piso, esposado, porque es lo que yo miré, tirado boca abajo, mi esposo ahí en el piso, solo gritando por ayuda.
¿El gobierno presentó cargos contra los agentes involucrados?
El gobierno nunca presentó cargos sobre esos agentes. Hasta ahorita yo no he entendido por qué no hubo cargos contra esos agentes. Si en los videos está claramente cómo, cómo asesinaron a mi esposo.
¿Cómo ha impactado la muerte de Anastasio a su familia?
La muerte de Anastasio para nosotros ha sido algo que no hemos podido superar hasta la fecha. Mis hijos, sus hermanos, su madre y su padre que murieron queriendo justicia, lucharon. Mis hijos, los más chicos, siempre, tengo mi niño, tenía 4 años, él me preguntaba que por qué habían matado a su papito. Y yo nunca he tenido respuesta, porque ni yo sé por qué. Tengo mi hijo de 24 años, iba a cumplir 12 años cuando asesinaron a su papá. Mi hijo es un joven encerrado en su cuarto, un joven que desde que asesinaron a su padre, lo mataron a él en vida también. Es un joven que vive encerrado, lleno de traumas, de dolor, que es lo que me dice que lo único que escucha son los gritos de su papá. Toda la familia hemos estado con este dolor, son 12 años de dolor, de angustia, de no saber por qué mataron a mi esposo, por qué.
¿Por qué tu familia pidió a la comisión que revisara el caso?
Pedimos la familia que la comisión revisara el caso porque cuando revisaron la primera vez el caso, no hubo cargos. Nosotros lo que queremos es que se haga una declaración, que se haga justicia. Queremos Queremos descansar, queremos un poco de paz en mi familia, porque esto que le hicieron a mi esposo fue un asesinato.
María, ¿has hablado con otras familias que han perdido un querido por las manos de la patrulla fronteriza?
He hablado con madres y familiares que han sido igual, les han asesinado a sus hijos, a sus hermanos. Yo he llorado con esas madres y sé por el dolor que pasan. Yo después entendía a la mamá de Anastasio cuando hablaba con esas madres, el dolor tan grande que sentía esa señora al mirar a estas madres que también lloran y siguen llorando porque no han encontrado justicia, porque nosotros estamos sufriendo y los oficiales están con sus familias felices, mientras mi familia y la familia de esas personas están destrozadas. No podemos vivir tranquilos, no tenemos paz, porque sin justicia no hay paz.
¿Qué es lo que esperes de este proceso?
Esperemos y se haga justicia. Queremos que se reabra el caso, que los oficiales que son involucrados y el gobierno pidan perdón a la familia por haber asesinado a mi esposo, que haga cambios en estas políticas de fuerza que tanto han hecho sufrir y que a mi familia la destrozaron. Mi familia está destrozada. Mi familia ya nunca va a volver a ser la misma.
Gracias, María.
Muchas gracias. La comisión va a iniciar su participación. Le voy a preguntar a cada comisionado si tienen preguntas y la declarante podrá contestar luego de ello. Inicio con las preguntas de la comisionada Roberta Clark, relatora para los Estados Unidos.
Thank you very much. And I do extend my solidarity and feelings of condolence on this tragedy that has happened to you and your family. I want to ask about the video that I think was referenced with your husband being assaulted. Can you tell us in that video how many persons were in the room with your husband?
¿Puede responder? ¿Tiene acceso a traducción? Sí.
Traducción, si me puede repetir la pregunta, por favor, mil disculpas.
Le puedo traducir. La comisionada Clark le quería preguntar, primero le expresaba su solidaridad y condolencias por lo sucedido, y quería preguntarle ella si en el video cuántas personas rodeaban a su esposo.
En el video se miran aproximadamente como 13 personas rodeándolo, se mira cómo lo patean, cómo le jalan su ropa, cómo le tiran con macanas y cómo se le pone la pistola eléctrica en su pecho.
And were these 13 people all in uniform?
¿Todas estas personas estaban con uniforme?
Sí, todas esas personas eran uniformados.
Thank you very much.
Gracias, comisionada. Le pregunto al primer vicepresidente Estuardo Ralón, que está conectado, si tiene preguntas.
Muchas gracias, presidenta. Solo quería manifestar mi solidaridad y no tengo preguntas. Muchas gracias.
Gracias. Le pregunto a la comisionada Margaret May Macaulay si tiene preguntas, segunda vicepresidenta.
Thank you, Madam President. I also wish to transmit my solidarity and sympathy for what the witnesses and her family went through and are still going through. I just wanted to follow up a question as well on Commissioner Clark's questions about, she said the people in the room were in uniform, did she recognize the uniform? Would she recognize the uniform that they wore?
No reconoceré el uniforme, pero yo pude mirarlos de frente y había que eran CBP, ICE y de la patrulla fronteriza. Entonces, en ese momento en el video no se mira el uniforme, pero yo los tuve de frente y miré sus uniformes.
Thank you very much, and I hope you get resolution very soon with you and your family.
Le consulto a la comisionada Rosemena, ¿tiene preguntas?
Gracias, Presidenta. Mis saludos respetuosos para la señora María y mi expresión de solidaridad también para acompañarla en este camino de dolor. Y como usted señala, su familia jamás podrá volver a tener su paz y sus formas de vida anterior. Igualmente se la extiendo a sus hijos que tienen este mismo sentimiento de dolor por la tragedia que se ha vivido. Mi pregunta, que también va en la línea del video, es, usted dice que inmediatamente después del funeral usted oyó, cuando salía, cuando usted dice que lo escuchó y pudo oír los gritos, escuchó, ¿cómo ese video se reproduce? ¿Por qué medio se estaba reproduciendo ese video que en primera instancia lo vio inmediatamente después del funeral y que luego, 2 años después, tiene la oportunidad de verlo ya como de frente? ¿Por qué medios, por qué salen esos videos y que llega usted a poderlos ver?
Ese día saliendo de la iglesia, alguien se acercó a mí y me dijo que había un video, pero alguien me dijo que no lo mirara porque estaba muy fuerte. Fue un medio de televisión, algo así. Le digo, cuando nosotros regresamos a casa después de todos los servicios, fue cuando el televisor estaba encendido en la casa porque habían dicho que iba a salir en las noticias, pero nunca yo me imaginé qué clase de video era. Cuando yo voy al baño, como les comenté, fue cuando yo escucho esos gritos de mi esposo.
Y cuando esos videos se transmiten, que se transmiten 2 años después, ¿bajo qué contexto la televisión expone esos videos? ¿Qué se estaba desarrollando? ¿Había una investigación? ¿Se hablaba del caso como para que públicamente estuviese siendo presentado ese video? ¿Cómo usted evalúa eso en el proceso de reclamo que usted hace a los Estados Unidos por esta situación?
Sí, pues el caso se hizo público, entonces los medios de comunicación siempre estuvieron interesados en qué estaba pasando, qué había pasado, con ese caso de mi esposo. Entonces se ha sido un seguimiento y es un seguimiento. Entonces así fue como estos videos salieron a la luz por personas que grabaron. No era ningún familiar ni nadie de nosotros, simplemente una persona que ese día iba cruzando para México cuando miró todo eso.
¿Usted utilizó ¿Usted utilizó ese video para presentar las denuncias formalmente ante las autoridades?
Esos videos se mostraron, los testigos declararon y aún así no hubo justicia. Mirando esos videos que están muy claros, ahí se mira realmente lo que pasó con mi esposo. Ahí se mira, ahí se escuchan los gritos de ese ser humano pidiendo ayuda.
Muchas gracias. Eso es todo, comisionada.
Muchas gracias. Señora María, yo también le quiero expresar mi profunda solidaridad desde la Comisión Interamericana por estos años de sufrimiento y por todo lo que usted ha padecido y definitivamente por lo sucedido a su esposo. Yo solo tenía una pregunta muy puntual. Usted nos ha contado el impacto que ha tenido esta situación en la familia, en los hijos. Yo quería preguntarle directamente a usted, en esta búsqueda de justicia, ¿se ha sufrido amenazas, maltratos? ¿Nos podía contar un poco más sobre eso, por favor?
Yo no he sufrido de ningún maltrato ni nada. Yo he estado bien, o sea, con este dolor y todo esto me hizo ser fuerte por mis hijos, porque les hice una promesa que íbamos a buscar justicia para su papá. Entonces, yo nunca he recibido ninguna amenaza para nada.
Muchas gracias, señora María. A continuación, la comisión escuchará la declaración de Rafael Barriga en calidad de testigo. El señor Barriga declarará sobre lo que presenció con relación a Anastasio Hernández Rojas en el puerto de entrada de San Isidro el 28 de mayo del 2010. El señor Barriga también relatará su experiencia cuando fue llamado a declarar ante un gran jurado en el Departamento de Justicia de los Estados Unidos. La parte peticionaria tendrá hasta 10 minutos para realizar el interrogatorio. Igualmente, el Estado nos ha informado que no realizará preguntas. Y finalmente, la comisión pasará a hacer sus propias preguntas. Sírvase, señor Barriga, declarante, sírvase indicar su nombre completo, lugar de nacimiento y lugar de residencia.
Bueno, buenas tardes a todos, primero que nada, y gracias por recibir estos testimonios que creo que son importantes para este caso. Mi nombre completo es Rafael Barriga Pulido. Soy nacido en México, en la ciudad de Tijuana, y también resido en la ciudad de Tijuana.
¿Jura o promete decir toda la verdad y nada más que la verdad?
Así es.
Le paso la palabra a la parte peticionaria para que realice el interrogatorio.
Adelante.
Gracias, señora Presidente. Mi nombre es Roxana Alzo. Soy una de las representantes de la familia de Anastasio Hernández Rojas. Señor Barriga, por favor, describe a la honorable comisión brevemente.
Perdón, no sé si podría hablar un poquito más fuerte o pegarse más al micrófono, por favor. No se le escucha muy bien.
Listo. Espero que eso... Ahora sí me pueden escuchar. En mayo de 2010, señor Barriga, ¿cuál era su empleo y por cuánto tiempo tenía dicho empleo?
Yo tenía en ese tiempo un puesto en la Oficina de Migración Mexicana, en el área de repatriación, que la función principal es recibir repatriados indocumentados por parte de la patrulla fronteriza y darle todo el proceso de apoyo posible para su reintegración a la sociedad mexicana.
¿Y dónde trabajaba usted?
Oficina de repatriación que estaba pegada en ese tiempo a la cerca divisoria entre México y Estados Unidos.
¿En cuál puerto?
En el puerto de San Isidro.
Quisiera ahora hacer algunas preguntas sobre lo que ocurrió el 28 de mayo de 2010, aproximadamente a las 9 de la noche. Por favor, describe a la honorable comisión qué pasó.
Bien. Trabajando en el turno nocturno recién iniciado hace unas horas, recién terminado un proceso de repatriación, a los pocos minutos ingresa una persona de sexo femenino alterada para decirnos que saliéramos rápido a la parte de afuera porque estaban golpeando a una persona de origen latino o mexicano. Ya habíamos terminado el protocolo anterior, salimos, o al menos yo salí, y empecé a escuchar gritos y llamadas de petición de alto a una golpiza, a una persona que estaba sufriendo algo ahí. Lamentablemente, a la vista en el primer momento no me fue posible ver debido a unas camionetas tipo Tajo que tenían estacionadas ellos en esa zona. Solo se lograba escuchar gritos de las personas que le pedían de manera enérgica a los inmigrantes dejaran de golpear a esa persona, que porque no era un animal, que basta de tanto golpe.
¿Por qué habían tantas personas? ¿Por qué se encontraba tantas personas civiles en ese momento mirando lo que estaba pasando?
Pues es que era una zona de cruce peatonal a unos metros de la salida al país. Y al ver la situación, los primeros que estaban se fueron acumulando, debido a la situación que vieron del amontonamiento de personas pegadas a la cerca, gritándole a los agentes de migración que dejaran de golpear a esta persona. Y el grito y el bullicio hizo que la demás gente que venía saliendo se quedara a presenciar eso.
¿Nos puede especificar qué gritaban?
Muchas cosas, pero entre ellas las principales que recuerdo es: basta de golpearlo, no es un animal, deténganse, paren por favor esto.
¿Y usted qué hace?
No podía hacer nada para detener dicha golpiza o dicho agresión, pero tuve la obligación de saber qué era lo que realmente estaba pasando, aunque no tuviera nada a la vista en el momento. Y solicité a algunas personas que recién salían que informaran a las que todavía estaban adentro, que me dieran más información sobre qué tipo de camionetas eran, qué placas tenían, descripción de los uniformes, cuántas personas podían estar ahí, y fue lo que hice.
¿Qué les contó? ¿Cuántas agentes estuvieron presentes en ese momento? ¿Qué les dijo los testigos?
En ese preciso momento me dieron un conteo no exacto, pero calculaban entre 8 y 10 oficiales.
¿Y qué pasó después?
Nada, al parecer continuaron los gritos, pero se alcanzó a escuchar también a la persona que estaba siendo agredida gritando que por favor lo dejaran de golpear con bastas llenos de dolor.
¿Y después qué pasó?
A los pocos segundos, diría yo, porque no podría calcular exactamente el tiempo exacto en que pasó, pero fue muy poco tiempo en el que, a mi forma de ver, para que dejaran de gritarles, lo movieron del lugar. Y fue cuando a mí se me permitió ver lo que se estaba haciendo con esta persona.
Cuando usted dice que lo movieron, ¿estás refiriendo a quién?
Que estaban castigando o lastimando.
Y ahora se sabe que esa persona es.
El señor Anastasio Hernández,
¿Y quién lo movió?
de la patrulla fronteriza y también de CBP.
Una vez que mueven al señor Hernández, ¿qué pasa?
Pasa lo que nunca me imaginé ver en el tiempo que llevaba como oficial. Traían a esta persona por el suelo, rodando, pateándolo, como si fuera un barril, sin importarles que la persona tuviera dolor.
Cuando usted dice que lo pateaban, ¿cuántos agentes y con qué fuerza?
Con la fuerza suficiente para provocar gritos en la persona. Y eran aproximadamente los que yo vi que lo iban golpeando entre 3 a 4 oficiales de todo el grupo que estaba ahí.
¿Y después qué pasó?
Lo alejan a una distancia aproximada de 30 metros de distancia, con la idea de que perdiéramos visibilidad y que no fuera claro lo que estuviéramos presenciando. Donde pasó lo peor que puede pasar a un ser humano del otro país. Humillaciones, golpes, insultos e ignorancia todavía de la gente que todavía pedía que le dejaran de hacer daño.
¿Y después qué pasa?
Esto no es fácil para mí, pero tengo que decir lo que vi. No puedo quedarme callado. Lo siguieron golpeando y después de querer incorporarse el señor porque sentía incomodidad, le sujetaron las piernas para tratar de sujetarlo, no en el suelo, sino hacia arriba. Y cuando el señor de alguna manera involuntariamente reaccionó, fue cuando aplicaron teasers en varias partes de su cuerpo, provocando que el cuerpo se convulsionara y temblara hacia arriba.
En algún momento, la noche del 28 de mayo de 2010, ¿usted habló con un oficial de los Estados Unidos?
Sí.
Por favor, ¿puedes compartir con la comisión qué pasó?
Claro que sí. Después de bastantes minutos de que la gente les gritaba y les decía hasta palabras fuertes por el mismo coraje que sentían, una de las oficiales se acercó lo más posible a la reja para tratar de controlar o de calmar a la gente que les gritaba.
¿Y qué pasó?
Cuando ya la tuve a una distancia suficiente para que me escuchara sin gritar, le pregunté solo dos cosas: que si no consideraba que eran demasiadas personas para controlar a una persona en el estado en que se encontraba. Y solo me respondió fríamente que no me preocupara por eso. Y cuando ya se iba a retirar, le volví a interpelar para preguntarle que si sabía cómo se encontraba de salud o en qué condición estaba el señor. Y solo volteó para decirme otra vez fríamente que no me preocupara, que él estaba bien, y se retira.
Señor Barriga, ¿usted vio a Anastasio agredir a un oficial de los Estados Unidos?
En ningún momento.
¿Considera usted que Anastasio constituía una amenaza para la vida o la integridad personal de los oficiales?
Definitivamente no.
¿De los testigos?
Tampoco.
2 años después, usted fue llamado a declarar ante un gran jurado de los Estados Unidos. Por favor, describe a la comisión cuál fue su experiencia ante el gran jurado.
Bueno, después de tenernos en una sala, porque no fui solo yo, fueron varios testigos que citaron, entre ellos la chica que tomó el video, que la mayoría pasaron primero que yo. Yo fui casi de los últimos en pasar. Y me trataron de repetir las preguntas que me habían hecho cuando estuvimos en Tijuana a los pocos días. Pero la insistencia, el tono de hacer las preguntas, incluso de las personas que integraban el jurado, a mi manera de ver, por la sensación, yo tenía la impresión de que de alguna u otra forma estaban queriéndome hacer caer o en contradicciones o que mi credibilidad estuviera en duda.
Muchas gracias. Ha terminado el tiempo. Pues inicia la Comisión Interamericana las preguntas. En primer lugar, la comisionada Roberta Clark.
Thank you very much for your testimony. I just have two questions. From the moment when you heard the commotion or the screaming to the conversation that you had with the officer on the day itself, 20th of May, how long was that period? Can you estimate?
No exactamente, pero si hacemos un cálculo lo más aproximado sin faltar a la verdad, fueron entre 5 a 8 minutos mínimo.
Mm-hmm. And from what you could observe, how many witnesses or people were around observing this beating?
¿Se refiere a los de agentes de migración o a la gente que pasaba por ahí?
No, the bystanders, the observers, those who were at the fence and observing the assault.
Ok. De ellos era un promedio de 10 a 12 personas.
And you said that you said 5 to 8 border control officers. How many were there assaulting, doing the assault? Do you recall?
Sí, al inicio, cuando me tocó ver por primera vez, yo conté 4 de ellos, pero al final eran más de ellos.
How many more at the end?
En promedio, 8 de ellos.
Thank you very much.
Muchas gracias. Le pregunto al vicepresidente Ralón si tiene alguna pregunta.
Muchas gracias, presidenta. Sí tengo una pregunta y sería si conoce el testigo cómo fue la asistencia médica, si llegó la ambulancia rápido o no, o si pudo percatarse de esa asistencia médica. Muchas gracias.
La asistencia médica no llegó hasta después de que le aplicaron los teasers, se dieron cuenta que su cuerpo no reaccionó a los estímulos que le quisieron hacer. Y algunos muy nerviosos comenzaron a moverse por todos lados, a hablar con sus teléfonos, y uno de ellos intentó moverlo. Cuando ya vieron que no reaccionaba, trataron de apoyarlo físicamente para ver si reaccionaba. Y al no hacerlo, mandaron pedir apoyo de ambulancias que no llegaron hasta después de 5 a 8 minutos.
No tengo más preguntas, presidenta. Muchas gracias.
Muchas gracias. Comisionada Macaulay.
Thank you, Madam President. Madam President, Mr. Barriga, thank you for coming to give your evidence to us today. I just wanted to understand what happened during this assault of the victim. When you said that they moved him, at first you couldn't see what was happening because of where they were, and then you said they moved him, and then you could see. How did they move him? Was he able to walk by himself?
No. No, lo
Could you
traían.
tell us? Tell us how they moved him.
En todo el tiempo que yo vi que lo movieron, fue pateándolo y rodando su cuerpo por el suelo.
Could you see whether he was handcuffed?
Así es.
Because could you hear the officers saying anything during their attack on this, the physical attack on the victim?
Nope.
And could you hear the blows, the kicks on his body?
No.
But you could see from where you were.
Así es.
Thank you very much.
Comisionada Rosemena, por favor.
Gracias, presidenta. Señor Barriga, también mi reconocimiento por por esta oportunidad de poder escuchar su testimonio. Usted señala que tuvo, luego de 2 años de los hechos, fue llamado a hacer una declaración. Una pregunta con respecto a qué era lo que se daba como explicación de lo sucedido. ¿Por qué ese ataque aquí a la víctima? ¿Se mencionó en algún momento las razones por las cuales estos agentes fronterizos habían actuado de esta manera? ¿Había algún tipo de explicación en ese sentido?
Desde ese día hasta hoy, ninguno.
¿Y por qué le pidieron que fuera a declarar?
Porque se rindió un informe de los hechos y yo fui quien lo tuve que hacer por órdenes de mi jefe para mantener la información correcta porque yo estaba como encargado de turno en ese momento. Y parte de mis obligaciones era reportar cualquier incidencia y cualquier situación anómala que se pudiera presentar dentro de la situación, dentro del horario de trabajo.
Entonces, a la fecha, ustedes, su oficina, su área de responsabilidad, nunca recibió ninguna comunicación de explicación de los hechos en ningún momento a la fecha de hoy.
No sé si mi oficina lo habrá recibido, pero por lo que a mí respecta, a mí nadie me ha comunicado hasta ahora el motivo ni el porqué de la agresión a esta persona.
Muchas gracias, señor Barriga.
Señor Barriga, muchas gracias por su participación en esta audiencia, por su contribución a la verdad y a la justicia. En estos momentos vamos a iniciar la parte de los alegatos. La parte peticionaria tendrá 15 minutos para presentar sus alegatos, posteriormente el Estado también por 15 minutos. Luego, si así lo desea, la parte peticionaria tendrá 5 minutos para ejercer su derecho a la réplica y el Estado 5 minutos para la dúplica y finalmente la comisión hará las preguntas del caso. Le paso la palabra a la parte peticionaria por 15 minutos.
Muchas gracias. Yo voy a dar los alegatos en inglés. Honorable Commissioners, members of the Secretariat, thank you for convening this hearing. I'll begin my arguments by detailing the facts related to the brutal beating and tasering of Anastasio Hernandez Rojas on May 28, 2010, and specifying the steps of border agents to cover up their responsibility for his death. I will then discuss the laws and systems that fostered impunity for Anastasio's death, and will end by underscoring the stakes in this case. There is overwhelming factual evidence, including eyewitness testimony, videos and audio recordings of the incident, depositions of the agents and medical experts, autopsies, a police report, and declarations by 3 former high-ranking federal officials with direct knowledge of the investigation that U.S. law enforcement agents tortured Anastasio and orchestrated a cover-up. On May 28, 2010, Customs and Border Protection agents detained Anastasio Hernandez Rojas, a longtime resident of San Diego, a father of 5, and a Mexican national. He was taken to a detention center where an agent kicked Anastasio and re-injured a previously broken ankle. CBP agents denied Anastasio medical attention and the right to file a complaint against the agent who assaulted him. Border agents said Anastasio did not behave like, I quote, a typical alien, but talked loudly, looked directly at the agents, and formally complained about his treatment. By insisting that he be treated with dignity, Anastasio had created a problem for the agents. They decided to deport him immediately. He was taken to a federally secure area for removal to Mexico, where from approximately 9 p.m. to approximately 9:25 p.m., at least 8 CBP and ICE agents punched, kicked, dragged, tasered, hogtied, and kneeled on Anastasio's neck and body, while at least 9 additional agents, so 17 in total, and dozens of onlookers watched. Today, you heard Rafael Barriga, a former Mexican immigration officer, recount the harrowing experience of watching U.S. border agents torture Anastasio. He said U.S. border agents treated Anastasio like an animal, that U.S. border agents beat and tasered Anastasio while he cried in pain, did not resist, and civilian witnesses begged them to stop. We know from other evidence, including eyewitness video, that after an agent deployed a taser 4 times, the last time in stun drive mode directly to Anastasio's chest for 12 seconds, Anastasio lost consciousness. Yet agents continued to kneel on Anastasio's back and neck, although he was unconscious, unarmed, restrained. They risked positional asphyxia, although he posed no threat to their safety and they cut off oxygen to his brain for 8 minutes. Their use of force lacked all proportionality because he posed no threat. The agent's use of force escalated progressively until Anastasio was unconscious and brain dead. It started with kicks, escalated to punches, then strikes with batons, and then electrical shocks, and then positional restraints and risking positional asphyxia. There was no effort to use less force. There was no effort to preserve his life. Autopsy reports confirmed that Anastasio suffered extensive injuries while in custody, including bruising and abrasions on his face and body, 5 broken ribs, and hemorrhaging of internal organs and neck muscles. Anastasio died after suffering a heart attack, cardiac arrest, and brain damage. His death was ruled a homicide. The United States has not refuted or even responded to these factual arguments. The United States seeks to justify law enforcement's use of force and the Department of Justice's decision to close the criminal investigation without pursuing charges by claiming that Anastasio was combative and assaultive. According to the United States, the legal system achieved justice for Anastasio and his family with a civil settlement and a closed criminal investigation. The notion that monetary compensation extinguishes the United States' obligation to investigate and punish those responsible for Anastasio's death runs counter to decades of inter-American case law. Inter-American case law is very clear. States cannot kill and pay in order to avoid international state responsibility. Anastasio's life has no price. With regards to the investigation, we do not dispute whether the criminal legal system worked. In our view, the system worked as designed because it was designed to shield federal law enforcement from accountability and not to protect the civilian population from law enforcement brutality. The effort to cover up law enforcement brutality began while border agents were still beating Anastasio, when at least 10 agents dispersed civilian eyewitnesses and erased images and video recordings from their cameras and cell phones. It continued as Anastasio laid in the hospital brain dead, when law enforcement began to fabricate a narrative that blamed Anastasio for his own death. James Tomczyk, who was in charge of CBP's Office of Internal Affairs, affirmed in his statement to this commission that during the morning briefing of May 29th, the day after the incident, Border Patrol was already claiming that Anastasio was not restrained, that he was standing, that he was combative when he was tasered. The very agencies responsible for Anastasio's death impeded and maneuvered the police investigation away from the truth so that their version of the incident would go unchallenged. During the first 15 hours, CBP agents assumed control of the crime scene and failed to preserve physical evidence. None of the border agents present the night of the incident notified the police of the incident. In fact, the police didn't arrive to the crime scene until the day after, when a reporter notified them what happened. When the police did arrive, detectives did not interview all the agents involved because Border Patrol did not provide a complete list of the involved officers. All the documents and forms in the San Diego Police Department's investigation lists Anastasio as the perpetrator and the border agents as the victims. Police detectives did not identify or contact any civilian witnesses to the crime. The only civilian witnesses police investigators interviewed came forward of their own accord. An eyewitness video of the tasering released 2 years after Anastasio's death directly contradicts the portrayal of Anastasio as the aggressor. An inadequate and manipulated police investigation was not the only gear turned to foster impunity in this case, however. I'd like to mention 3 more. First, perhaps one of the most effective instruments of impunity was the U.S. Border Patrol's Critical Incident Team. These are clandestine cover-up teams operated by U.S. Border Patrol for at least the last 30 years. The San Diego Critical Incident Team was notified and intervened before the police. Critical Incident Team members participated in incident briefings, seized evidence, controlled the witness list of border agents for police investigators, were present at police interviews of agents, and even questioned witnesses. The Critical Incident Team intervened in the investigation in all these different ways, although they lacked independence, they lacked impartiality, and they did not have a legal authorization from Congress to investigate use of force incidents. Critical Incident Team members also destroyed video evidence, altered government documents, and inappropriately used an administrative subpoena to acquire Anastasio's medical records, and then refused to give those records to the police investigators. Former Assistant Commissioner Tom Scheck described the use of the administrative subpoena as, I quote, illegal and potentially obstruction of justice. A second gear of impunity that was turned in this case is US law and CBP policy on use of force, which permits acts of force that would be considered excessive under Inter-American standards. International human rights standards on use of force are guided by the imperative of protecting the right to life, a supreme, non-derogable right from arbitrary deprivation by the state. The American Declaration requires that state agents only use force that is legal, necessary, and proportional as a last resort. State agents must always use persuasion and de-escalation tactics. The decision to use force must also be free from discrimination. The cornerstone of US law and policy regulating the use of force is the objective reasonableness standard. Under this standard, the focus of a legal inquiry is on the perception of danger and the subjective knowledge of state agents. The US standard is not about preserving life of the civilian, but the officer's perception of danger, even when the agent's belief about the level of danger is mistaken. In an amicus brief in support of the petitioners in this case, Erwin Chemerinsky, a renowned scholar and expert in use of force, observed that the objective reasonableness standard means that US law does not turn on whether the officer was threatened, but rather if the officer perceived a threat. That is how in the United States, beating and tasering a man handcuffed on the ground is deemed objectively reasonable, and why police investigators in Anastasio's case never bothered to identify or interview civilian witnesses, because it was the officer's perception of danger that mattered. This focus on the state agent's perception of danger, combined with a lack of regulation, transforms conduct that is excessive under international standards into objectively reasonable in the United States. At the time of Anastasio's death, US law and CBP policy did not require state agents to use the minimum amount of force necessary, or to use a type of force that is proportionate to the threat posed, or to exhaust available less harmful force alternatives. US law and CBP policy permitted the use of tasers, a weapon described by international bodies as a lethal force device in wide-ranging circumstances that involved no serious threat to life or safety. The last gear of impunity that we see in this case is the use of the secret federal grand jury. The US Constitution requires federal prosecutors to convene a federal grand jury to charge an individual for a federal crime. Federal grand jury proceedings must be conducted in secret. Contrary to Inter-American case law, these secret proceedings block the access of the family and society to information, to the truth, and prohibit family members' participation. In some, US law shrouded the criminal investigation of a law enforcement killing in impenetrable secrecy. I'd like to end with reflections about the stakes of this hearing. We expect that today the United States will spend its time trying to relitigate the admissibility report and recite details about policy changes at the margin without addressing our specific and serious allegations of grave human rights violation. That position is disrespectful to this family that has waited for 12 years to be on a level playing field with the United States before an impartial and independent panel of experts. It is also a disservice to the truth. U.S. Customs and Border Protection is the largest law enforcement agency in the country. The 20,000 agents stationed along the border proudly self-identify as a paramilitary force. This law enforcement force is waging war on migrants. Because of the tenacity of an extraordinarily brave family, we've been able to expose the anatomy of violence and the mechanics of impunity on the border. Maria Puga, she testified today, sees this case as an opportunity to pursue true justice, an opportunity to create lasting change. Through the years, this family has asked the same question over and over again. How can 17 agents of the nation's largest law enforcement agency beat to death a man in public in front of dozens of eyewitnesses on videotape without consequences? We ask the United States to contend with all that went wrong to allow just that to happen. Earlier this year, US President Biden issued an executive order acknowledging the disparate impact of law enforcement violence in Black and Brown communities and committed to address it. This public hearing about an extrajudicial killing by US law enforcement of an unarmed Latino man is an opportunity for the United States to publicly demonstrate the strength of that commitment. We ask the United States to rise to the occasion and provide the family measures with a measure of truth and justice. We urge the Commission to reject any effort by the United States to distract from the merits and focus its attention on determining the United States' responsibility for violations of the American Declaration, including Articles 1, 2, 18, 25, and 26. We request that the Commission, among other measures, instruct the United States to reopen the investigation of Anastasio's death, to amend use of force laws and policies.
Muchas gracias.
Gracias.
Muchas gracias. Muchas gracias. Estamos ya sobre el tiempo. Le doy la palabra al Estado para los alegatos, por favor, por 15 minutos.
Good afternoon. My name is Thomas Hastings, and I am the interim permanent representative of the U.S. government to the Organization of American States. I'm joined today by two colleagues from the U.S. Department of Homeland Security, Peter Mina and David Bova, who will provide most of the substance of the U.S. government's remarks today. But in my introduction, I would like to make 3 points. First, I want to thank the witnesses for sharing their testimony and to thank the petitioners for raising their concerns surrounding the death of Mr. Anastasio Hernandez Rojas. While we will not be discussing or debating today the details of what happened in May 2010, it was clearly a tragic event leading to the loss of life, and in your case, Ms. Puga, the loss of your husband, for your children, the loss of their father. You do have our sympathies, and I thank you for being here today. Second, to the members of the Commission, thank you for the opportunity to participate in this period of sessions. As I will explain in a few minutes, we do have a difference of opinion on legal grounds regarding the admissibility of this petition before this Commission. But nevertheless, the US government is committed to engaging with this body on human rights issues, including in our own country. We are committed to a strong and active Inter-American Commission on Human Rights, and I hope that our presence here today, myself and my colleagues from the Department of Homeland Security, demonstrates that commitment. I would like to provide a brief procedural overview of this case before registering my third point, which is our legal concern about this hearing today, and then handing over to my colleagues. This petition arises out of the death of Mr. Hernandez Rojas on May 31st, 2010. As the Department of Justice described in a detailed press release in 2015, the department conducted a comprehensive criminal investigation into Mr. Hernandez Rojas's death. A thorough review of the case by experienced federal prosecutors determined that the evidence was insufficient to pursue federal criminal civil rights charges, or to prove beyond a reasonable doubt that Customs and Border Protection personnel, CBP personnel, had violated federal homicide statutes. Additionally, the petitioners filed a civil lawsuit against the U.S. government, including CBP agents, in the U.S. District Court for the Southern District of California in 2011. That action was subsequently dismissed upon a joint motion by the petitioners and the U.S. government because the parties had reached a settlement in the case. Under that settlement agreement, the U.S. government provided $1 million to the estate of Mr. Hernandez Rojas to settle, and I quote, each and every claim of any kind, whether known or unknown, arising directly or indirectly from the acts or omissions that gave rise, end quote, to the civil case. The United States maintains that that settlement agreement precludes any further action in this case. As the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights have repeatedly stressed, international human rights bodies are set up to work as complements to domestic courts and other domestic processes. And this principle of complementarity is reflected in the requirement of exhaustion of domestic remedies. That is, if a petitioner has received an effective remedy in the domestic system, then his or her claim is not admissible before the international forum. Therefore, the United States urges the Commission to reconsider its intervention in a matter that has been voluntarily settled in the domestic system. Let me now turn to my colleague from the Department of Homeland Security, Peter Mina.
Thank you so much. Distinguished commissioners, petitioners, secretariat staff, and colleagues, on behalf of the United States Department of Homeland Security, or DHS, I welcome the opportunity to participate in today's hearing. My name is Peter Mina, and I currently serve as the DHS senior official performing the duties of the Officer for Civil Rights and Civil Liberties. In this role, I am designated by federal statute to protect civil rights and civil liberties and to ensure that the department meets our international human rights treaty obligations. Since assuming this role, I and my staff have been working to ensure humane treatment for all individuals seeking entry at the southwest border, to ensure that their treatment is consistent with our domestic laws and international obligations. Throughout all of our work, we have been particularly focused on those who are the most vulnerable or disproportionately impacted, such as children, families, women, Black and brown migrants, LGBTQI plus individuals, and those with medical needs. I'd like to begin by offering my deepest condolences to Ms. Puga and to the entirety of Mr. Hernandez-Rojas' family. While I'm unable to address the merits in this case, there are a few points I'd like to highlight. First, DHS enforces strict standards of conduct that apply to all of its employees. These standards apply whether the individuals are on or off duty. Several different oversight bodies also investigate deaths resulting from use of force and follow up on civil rights and civil liberties complaints. Second, in January of 2021, U.S. Customs and Border Protection, or CBP, issued a new use of force policy and use of force administrative guidelines and procedures handbook, and both are available to the public online. Third, the CBP use of force policy is based on the constitutional standard of objectively reasonable force, federal case law, and applicable DHS and CBP policies. It states, respect for human life and the safety of the communities we serve, as well as CBP's officers and agents, is paramount and shall guide all employees in the performance of their duties. My colleague from CBP, Mr. David Bova, will be speaking next, will address the numerous updates to DHS and CBP's force policies and training in more detail, as well as the role of CBP's Office of Professional Responsibility in investigating cases of employee misconduct. I will provide further details about other accountability and investigative mechanisms and remedies for excessive force. The DHS Office of the Inspector General, or OIG, is the primary agent that investigates alleged misconduct by CBP personnel. OIG investigations may result in criminal prosecutions, fines, civil monetary penalties, administrative sanctions, and personnel actions. The OIG maintains a 24-hour complaint hotline. My office, the DHS Office for Civil Rights and Civil Liberties, or CRCL, also investigates complaints alleging excessive use of force by CBP personnel. These investigations focus on policy and procedure concerns. Where concerns are identified and recommendations made, CRCL works with CBP to address concerns and mitigate any civil rights and civil liberties issues related to policies, directives, and encounters to ensure actions are consistent with best practices and DHS policy. In addition, CRCL receives notification of all non-employee deaths that occur in CBP custody, as well as deaths involving use of force by law enforcement officials. Upon notification of a death, CRCL requests relevant records and information from CBP, which CRCL reviews to determine whether a more detailed investigation is warranted. If so, and the investigation is conducted. As with all CRCL complaint investigations, if issues of concern are found, recommendations are made directly to CBP leadership. Throughout all this work, our overarching aim is to ensure that individuals at risk of harm are protected. I thank you for this opportunity to address the Commission and appreciate your attention to these issues. And let me turn it over to my colleague, Mr. David Bowe.
Thank you very much, distinguished Commissioner, petitioners, Secretariat staff, and colleagues. It is an honor to appear before you today on behalf of U.S. Customs and Border Protection. My name is David Bova, and I am the Director of the Use of Force Policy, Force Review and Compliance Branch of the Law Enforcement Safety and Compliance Directorate at CBP. I'm going to talk a little bit about CBP's use of force policies, particularly updates that have occurred since the regrettable death of Mr. Hernandez Rojas in 2010. First, in 2014, CBP issued an updated use of force policy, guidelines, and procedures handbook designed to provide enforcement personnel with a single use of force reference. The policy incorporated best practices and recommendations from use of force reviews conducted in 2012 and 2013. Notably, CBP reviewed and redesigned its basic and advanced training for use of force instructors, purchased use of force simulator systems designed to provide a more realistic training experience, and updated policy guidance on the use of tasers, including that tasers should be deployed for one standard cycle, and then the situation should be evaluated to determine if subsequent cycles are reasonable and necessary. If the use of a taser is unsuccessful, another reasonable option should be used, and subjects should not intentionally be exposed to more than one taser at a time. In September 2018, DHS issued a department-wide use of force policy, which affirms the duty of all DHS employees to report improper uses of force and to intervene to prevent or stop the use of excessive force. The policy also requires DHS components agencies to provide use of force training, including de-escalation techniques. In January 2021, CBP issued a new use of force policy and use of force administrative guidelines and procedures handbook. CBP implemented an extensive training program on the new policy and handbook between February and April of 2021. The new policy and handbook incorporate agency-wide training, de-escalation, a duty to intervene, reporting standards, and also prohibit chokeholds and neck restraints. DHS has also strengthened its training on use of force. The Federal Law Enforcement Training Center, FLETC, a component of DHS, trains more than 90 federal agencies, including CBP, as well as partner organizations such as state, local, tribal, campus, and international law enforcement. FLETC's basic and advanced law enforcement training programs include lessons on use of force and de-escalation. For instance, FLETC incorporates de-escalation concepts into its training on tasers. FLETC also integrates use of force and de-escalation principles into its courses on physical techniques, firearms, driving, tactics, criminal investigations, and behavioral sciences. Per the 2021 CBP use of force policy, CBP conducts in-service use of force training on a quarterly basis. Notably, the new policy mandates annual taser familiarization and awareness training for all officers and agents, even if they are not certified to carry a taser. All CBP employees also receive anti-corruption and introduction into law enforcement professionalism training. Employees participated in a series of discussions that address what CBP officers and Border Patrol agents should and should not do in various situations. In addition, they are trained to report any suspicious behavior and on the consequences of participating in corrupt behavior. All CBP trainees are instructed on the requirement to treat all individuals humanely and professionally, which is reinforced throughout their careers. Notably, on September 29, 2021, DHS announced the formation of a Law Enforcement Coordination Council to comprehensively assess a broad range of law enforcement matters, including its law enforcement policies and training. This council, chaired by the Secretary of Homeland Security, conducts comprehensive reviews to ensure more fair, equitable, and impartial policing, as well as officer and community safety. It includes the leadership of every DHS law enforcement component, including CBP, as well as leadership of DHS oversight offices. Over the last decade, CBP has also enhanced its oversight and transparency around use of force. A national use of force review board and local use of force review boards were created in 2015 to review all CBP use of force incidents. The national board is comprised of senior officials from across CBP, as well as officials from DHS oversight offices and other government agencies. The national board reviews all incidents involving the use of deadly force or those that result in serious bodily harm or death. It conducts an objective review of each incident to determine if the use of force was consistent with CBP policy, identify any potential misconduct, and assess any issues involving training, tactics, policy, or equipment. Incidents involving less lethal force are reviewed by the local boards. In May 2017, CBP began tracking and publicly reporting assaults and uses of force on its website. CBP tracks all uses of force by agents and officers, as well as assaults against law enforcement, in a comprehensive database called the Enforcement Action Statistical Analysis and Reporting System. The system, which was initially developed in 2010, was later expanded to capture additional metrics and to help provide a better understanding of when, how, and why officers and agents use force. In 2015, CBP's Office of Professional Responsibility, or OPR, was established, which, as my CRCO colleague mentioned earlier, investigates cases of employee misconduct. CBP OPR may collaborate with both the OIG and the FBI. OPR is a standalone office led by an assistant commissioner who reports directly to the CBP commissioner. OPR issues a public annual report containing statistics regarding misconduct and corruption. In conclusion, CBP is committed to building trust between its officers and the people they are serving, and is also committed to holding officers accountable for any abuses of power or excessive use of force. We thank the Commission for giving due consideration to the extensive efforts to address use of force within DHS and CBP.
Muchas gracias. Le doy la palabra ahora a la parte peticionaria por 5 minutos para la réplica.
I'm Andrea Guerrero, and for the last 2 decades, I've worked with colleagues around the country to monitor border policies and advocate for reform. We recognize that the state has made changes to use of force policies in the wake of Anastasio's death, but they fall far short of international human rights standards and have not and will not prevent further abuse and impunity. Updated use of force policies, both at DHS and CBP, do not reflect best practices and are still based on the reasonableness standard, not the international standard of necessary and proportional. In fact, the 2021 CBP policy states, and I quote, "There is no duty to meet force with equal or lesser force." While new policy now limits the use of electronic control weapons or tasers to 3 cycles, which is only 1 less than Anastasia was subject to, it does not prohibit their use in custody nor limit them to a proportional response. Though policy now limits the use of chokeholds and neck restraints, it does not outright prohibit them, as the state asserts, and it evaluates their use under the reasonableness standard. Administrative guidelines, handbooks, and training that the state points to all follow the deficient reasonableness standard and would not have prevented Anastasio's death. Since his death, nearly 250 people have died in encounters with U.S. border agents. In addition, every year across all 50 states, police kill more than 1,000 people who are disproportionately Black and brown. Only a handful of officers and no border agents have ever been convicted because the reasonableness standard favors them and justifies their perceptions to use force. The dangers of reasonableness based on perceptions are compounded by racial profiling, which the state explicitly permits federal agents to use in the border region. Per the state's own data, use of force by border agents is on the rise and has increased over 3 years from nearly 600 incidents a year to 900. That amounts to roughly 3 per day, with little to no accountability. All of the accountability bodies that the state points to are internal to the Department of Homeland Security, and all of them rely on biased management teams that seek to mitigate liability, which is neither impartial nor independent. This case exposed systemic cover-ups by management teams called critical incident teams and prompted 5 investigations, including from representatives from the state here today. And it led to the elimination of these specific teams, but there has been no accountability for the harm they cause. There's been no reopening of investigations, no removal of agents engaged in cover-ups, and no end to other management interference. Moreover, these internal bodies have concurrent statutory authority with external bodies like the FBI to conduct criminal investigations, structurally compromising any investigation. The highest internal body, Office of Inspector General, is currently under investigation itself for lack of integrity. Another internal body represented here today, Civil Rights and Civil Liberties, has never, to our knowledge, referred an agent for prosecution for lethal force. The internal affairs body, Office of Professional Responsibility, lacks credibility. It has deemed all killings and nearly every serious use of force incident as in compliance. For victims of abuse, access to justice was already difficult with deficient policies and faulty investigations that hardly ever result in criminal charges and have never resulted in a conviction. Now the doors of the civil justice system are closing too. The U.S. Supreme Court has ruled that victims of border agent abuse can no longer bring claims of constitutional violations. If Anastasio's family attempted to do so today, the courthouse doors would close on them. In 2020, the agency was designated as a security agency and is no longer subject to transparency laws. It is now larger. CBP is now larger than all other federal law enforcement agencies combined. It asserts jurisdiction over the whole of the United States, within 100 miles of the border, an area that encompasses 2/3 of the population. It asserts the right to stop people in the streets, detain and search them without probable cause, and use force without repercussions. It is the most powerful law enforcement agency, the most abusive with the least accountability. CBP is the greatest threat to human rights in the United States, and it warrants a close examination by this commission.
I would like to quickly refer to the implications of the United States' reluctance to engage with the merits in this hearing. The United States has now stated in this hearing that it will not address the merits. We request that the commission apply Article 38 and presume as true the facts that have not been contested by the United States. I would also like very briefly to address the waiver mentioned by the United States. Petitioners cannot waive their right to an exhaustive, independent, and impartial investigation. That cannot waive their right to full reparations of core non-derogable rights, such as the right to life and personal integrity, and they cannot waive the protection of Jus Cogens norms, such as the prohibition of torture and discrimination. Thank you.
Gracias. Le doy la palabra al Estado para la dúplica. El Estado tiene 5 minutos.
First, I'd like to state unequivocally that we take all allegations of use of force by CBP along the southwest border extremely seriously. Second, CRCL's compliance branch currently has an open investigation into the U.S. Border Patrol's critical incident teams, or CITs, as does Congress and the General Accountability Office. CRCL's investigation is based on a letter to Congress dated October 27th, 2021, from the Southern Border Communities Coalition, alleging that the CITs were covering up any wrongdoing by Border Patrol agents, as well as an article in the San Diego Union Tribune dated October 28th, 2021, alleging that the CIT unit in San Diego had destroyed evidence in the case of Mr. Hernandez-Rojas' death to protect the agents involved. CRCL's investigation, which is ongoing, is focused on the allegations concerning the CIT's oversight role, the responsibility, authority, independence, procedures, and involvement in the criminal and use of force incident team investigations. In May of 2022, CBP announced its decision to disband the critical incident teams, effective October 1st, 2022. The teams have now been disbanded and CBP OPR has assumed all of their responsibilities. Nevertheless, CRCL is continuing its investigation, and we believe that when it is complete, the investigation will provide valuable feedback and ensure the individual civil rights and civil liberties are protected in future investigations. Thank you again for this opportunity to address the commission, and I'll turn it over to my colleague, Mr. Bova.
Thank you again. DHS continues to engage in efforts to better inform its use of force policymaking. For example, on September 30th, 2020, the DHS Office of Partnership and Engagement organized a simulation experiment focused on law enforcement use of force. In April 2021, DHS, with support from George Mason University and the Homeland Security Systems Engineering Institute, concluded the 2-week use of force simulation experiment. The goal of the experiment was to deter and reduce fatalities and injuries due to law enforcement use of force through an understanding of the factors that contribute to each officer's decision-making process. It was also designed to provide law enforcement with evidence-based data to examine and evolve policies and procedures and improve operational techniques. Thank you.
Thank you again for all who are participating. The state has nothing further at this time.
Muchas gracias. Entonces vamos a iniciar desde la comisión nuestra participación. Le pregunto en primer lugar a la comisionada Clark.
Thank you very much. I want to thank all who have made presentations this afternoon. I have a few questions for the state, maybe 3 or 4 questions. So the first one, the state, as I understand it, representatives of the state are arguing that the settlement of the civil suit precludes the taking of any further action. On the other hand, the petitioners argue that what is being requested by the family of Anastasio is that the state meets its independent and autonomous obligation to exercise due diligence in investigating the homicide of Anastasio to arrive at accountability. So that's an independent obligation outside of the settlement of the civil suit. So I want to ask the representative of the state whether or not they understand, was it their understanding that what is referred to as a waiver of further action, was it made clear to the family members of Anastasio that this included waiver of criminal proceedings? That's the first question. Secondly, in relation to what was presented by both Mr. Mina and Mr. Bova, on I think Mr. Mina, you spoke about the strict standards of treatment, and I had the impression, and I may have misunderstood, but I had the impression that you were talking about strict standards of treatment in 2010, and Mr. Bova has spoken at length about the improvements around the use of force policy. But thinking about the standard of treatment in 2010, would you describe what has been presented to us today, that Mr. Anastasio was beaten, he was tasered, he was kicked for a period of 5 to 8 minutes by between 4 to 8 men in the presence of at least 13 observers? Would you describe that treatment to meet the strict standards of treatment back in 2010? And similarly, Mr. Bova, when you're talking about the improvements or the changes in the use of force policy, would you consider that what we've heard today about how Mr. Anastasio was treated by border control officers, would you consider that to fall within the language of humane and professional, which now describes the new policies? And lastly, I want to come back to the question of torture. Does the state consider that the prohibition against torture to be a feature of international customary human rights law binding on the United States of America? Thank you.
Muchas gracias. Le doy la palabra al Estado para que pueda responder las preguntas.
Thank you, Commissioner Clark. We note those questions and we will take them back for response.
Solo para precisar, ¿van a responder en este momento? Van después. Ok. Toman nota de las preguntas entonces para
No.
más adelante.
Right, we're following the
Por
agreed format.
escrito.
Yes, we're taking these
Ok,
back.
por escrito. Gracias. El comisionado Ralón me informó que no iba a hacer ninguna pregunta, entonces le doy la palabra a la segunda vicepresidenta, Margaret May McCall.
Thank you very much, Madam President. I do have a question or two for the United States representatives here. And I think my question is directed to the use of force officer who spoke. I'm sorry, I don't recall your name. And the first question is, in light of the fact that the United States has made adjustments, amendments, improvements to its use of force protocols in your officer corps, do you admit then that what existed in 2010 was not acceptable in the judgment of right-thinking members of law and international human rights law? And even within security groups around the world, and in particular our region, the Interamerican region. And secondly, do you also expect us to accept that because of the improvements in your training of use of force and to your officers, that every single one of your officers abides by the standards, the means, the conduct, and what have you that you have trained them to use in the execution of their duties? In other words, are you saying that by the mere fact of training these officers, large number of officers, that every one of them would strictly apply every single aspect of their training in relation to persons who they detain at borders? Thank you.
Nuevamente le pregunto al Estado si va a responder en este momento las preguntas.
Thank you again. No, as we understand, we're following the format that was agreed to and sent to us by the Commission, and we'll be taking these questions back on behalf of my colleagues as well.
Ok. La comisionada Rosemena.
Gracias, Presidenta. Una pregunta a los peticionarios respecto a la explicación o la argumentación que ustedes plantean para señalar que estos cambios, estos ajustes, estas reformas no abordan de la manera más exacta esta falta del principio de una razonabilidad objetiva y que se mantiene, a pesar de todas las reformas que se han hecho, se mantiene esta posibilidad de, frente a la percepción del peligro, la actuación de la policía. Me gustaría el razonamiento de ustedes con respecto a ese planteamiento, pero le voy a hacer la pregunta al Estado también, o espero también para que sí. Y entonces la pregunta al Estado, este acuerdo que se dio de carácter civil para Estados Unidos representó un reconocimiento de la responsabilidad de los hechos o sencillamente una vía administrativa para atender un tipo de respuesta. Y en ese sentido, sobre la responsabilidad, cuando las personas están bajo la custodia del Estado, se redobla este deber, esta obligación de garantes por la vida y la integridad de las personas. Entonces, este principio de obligación, y sí, es del derecho consuetudinario, de obligar, el Estado como el garante de la vida de las personas que están bajo su custodia. Entonces, me gustaría esa reflexión sobre el Estado, respecto del Estado.
Gracias. Le doy la palabra a la parte peticionaria en primer lugar.
Thank you very much. I'll begin by referring to the objective reasonableness standard. Our position is that U.S. law on use of force is inconsistent with international obligations. International obligations only authorize force that is necessary, proportionate, and legal, and the United States uses a very different standard, objectively reasonableness. And under that standard, stacks the deck in favor of law enforcement, because it all turns under this standard on the subjective perception of agents as to the level of danger they face. US law does not require de-escalation, does not require the use of alternative uses of force or less harmful use of force. US law also takes into account the severity of the underlying crime and not the level of threat exclusively that is posed by the individual to officers and bystanders. And so we are asking, as a measure of non-repetition, that the United States bring its law on use of force into conformity with its international standards. Lastly, I would just like to express the severe disappointment and shock to hear the United States today, in a case of an extrajudicial killing, in a case of excessive use of force against an unarmed Latino man, simply read the text of a website and just read an answer that they had already given the Commission, and return to issues of admissibility that are not relevant to these proceedings. We expected more from you, given all that what this family has gone through to reach this hearing today.
Gracias. Yo tengo una pregunta muy concreta, dos preguntas al Estado, muy concretas, y entiendo que las van a responder luego. Y van en la línea de lo que decía la comisionada Clark y la comisionada Esmeralda Arosemena. The influential restatement on foreign relations to the United States, well known as the restatement, defines jus cogens to include at minimums, the provision of torture or other cruel, inhuman, or degrading treatment of punishment, among other cases. So my question is, what is your opinion about that? Because this is what the restatement say about jus cogens and provision of torture. And the second question is also referring to the very well-known case, Filartiga versus Peña Irala from 1980, that it was a landmark case in the United States concerning torture. So my questions are on that. What are your opinion on these two issues concerning, relacionados a este caso que estamos viendo? Dicho eso, y entonces entendiendo que el Estado va a enviar sus respuestas posteriormente, sí. Sí, todas, absolutamente todas, comisionadas. Entonces, antes de dar por concluida esta audiencia, quiero agradecer la participación del ilustre Estado de los Estados Unidos y de la distinguida representación de las presuntas víctimas. Quiero recordar a las partes que tienen un plazo de 30 días a partir de hoy para presentar sus observaciones y respuestas escritas. Doy por cerrada esta audiencia. ¿Sí? ¿No? La comisionada Clark tiene una pregunta adicional.
Just one question, and we can get the answer in submissions. And it's a question for the petitioner. I don't. The question again on the the perception of threat. And I understand that under the US law, at least it's been said to us today that it's a different standard. But in any event, whatever the standard is there evidence that's required to be presented to support the perception of a threat?
Pueden responder ahora los peticionarios, ¿no? Tenemos 6 minutos todavía.
Essentially, it's the perspective of the officers. And in trainings, law enforcement are told to express whether they feel danger or fear after an incident of use of force. And I think for those of us who live in the United States, we've seen over and over and over again these cases deemed objectively reasonable use of force when to our eyes it looks like brutality and torture, because our laws allow excessive use of force that would be excessive under international standards. So it turns on the officer's statement about what level of threat the officer felt at that moment, which is one of the reasons we believe police investigators in this case did not try to identify and interview any of the dozens and dozens of eyewitnesses that witnessed Anastasio's beating and tasering.
And if I could add, this issue is further detailed in the amicus brief that was submitted by law professor and constitutional scholar Erwin Chemerinsky to this honorable commission. And just to put a finer point on what my colleagues said regarding reasonableness and perceptions, in Anastasio's case, the agents stated in the record that they perceived his carrying of a water jug as a threat, and that was used to justify kicking his leg and injuring him. They perceived his complaints about his injury and his request for medical attention as a threat. So they put him in a car, drove him to the border, and beat and tased him. They perceived him writhing in pain as a threat. So they tased him some more, put him into a positional asphyxiation until he stopped breathing. All of that was deemed reasonable and justified their lethal use of force.
Muchas gracias. Estamos todavía dentro del tiempo de preguntas, solamente para dejar nota que está todo dentro del procedimiento. Y ahora sí, antes de dar por concluida la audiencia, como decía, quería agradecer a la ilustre representación del Estado de los Estados Unidos, y también a la representación de las presuntas víctimas. Les recuerdo que tienen 30 días a partir de hoy para, por favor, enviar sus observaciones por escrito. Doy por cerrada esta audiencia. Muchas gracias.